Hello everyone, welcome to this 9th international workshop, which will be conducted on a span of 3 days, starting from the 23rd to the 25th of July. Mediate Guru is a social initiative led by members across the globe. The aim of this organisation is to bridge the gap between the general public and litigation. We are creating a social awareness campaign showcasing mediation as the future. We've conducted a series of successful webinars and have a reach in more than 100 countries around the world, with an international family growing each day. We strive to provide you the best lecture series from the best speakers so that you can add value to your legal studies and your legal career. I feel honoured to welcome our esteemed speaker for the session today, Mr. Edward Miller. Edward is an experienced solicitor-advocate. After originally training as a barrister, Edward was admitted as a solicitor in 2008. His main areas of expertise are in financial services, cross-border litigation, property litigation, and company commercial litigation. He also has experience in banking litigation and offshore contentious trusts. Edward's clients have ranged from bridging lenders, high net worth individuals, international companies, as well as sports and media personalities. I will now pass the stage to Edward, and I remind you that you can all leave your questions in the chat box below.
Thanks, Phoebe, for that introduction, and thanks for Mediate Guru for inviting me on to speak for this webinar. I think I've been associated with Mediate Guru for probably about a year now, and it's been my honour to work and assist them on a few moots and other competitions, and obviously for the segment today. When I was asked to do a presentation on mediation, I was rattling my brain, and I thought what would be useful for me as someone just setting out or starting out on their career, who probably knows the legal and institutional basics of what ADR and mediation is. I thought I'd come up with something more practical for everyone, just practical tips and experiences. And what I'd like to say, well, two things. One, this is concentrating on mediation, that these tips for anything such as negotiating contracts and or other settlements out of the formal style of mediation. And I'd also like to say that these are my own tips, and you, through your career and through your experience, will probably have your own tips of creating that rapport with not only the mediator, but also your own client, also the other opponents on the other side. So just let me just get the slides in place, just bear with me. So this is what we're going to be speaking about today, or I'm going to be speaking about today. So I'm going to take you through each of these, and I'd like to set out what the purpose of a mediation is and what we're actually trying to aim to do at the end, and why creating that rapport is going to be helpful to hopefully reach a settlement at the end of it. So without wanting to teach you to suck eggs and to tell you something so obvious of what mediation is, I do think at some point when you are invited to a mediation for your clients in the course of a dispute, it is actually useful to actually think, well, actually, what is a mediation? And then come on to the next slide, what's the purpose of the mediation? So just going through some of the basics, mediation is a form of alternative dispute resolution, which that effectively means, in a nutshell, it's trying to resolve a dispute outside the formal court process. There are practitioners who do include arbitration as a form of ADR, and quite rightly, they are right. But in terms of what mediation, is slightly different than a formal arbitration or court process. Effectively, it's an agreement between the parties to a dispute to try and settle their case outside of the court, or, as I say, potentially in an arbitration, or potentially no one's actually issued any proceedings, or there's a potential dispute between them, or a potential issue, or even you can have mediation because you're trying to negotiate the terms of an agreement going forward, a sales agreement, a contract of employment, anything. It is relatively cheap, or cheaper than going through a formal court process. And I say relatively cheap. It all depends on the length of the mediation, the number of parties, what legal representation you're having, whether that's your solicitors, your advocates, or if you've got any experts. But generally speaking, if you do reach a settlement, you will be much cheaper than progressing the claim to the end and having a decision by an arbitrator, a panel, or through the court. It's also confidential, and in England, Wales at least, it is something called privileged and without prejudice, which means, well, usually means, and there are some exceptions, and I won't go them in detail at this stage, it means anything you say in that mediation is going to be confidential between the four walls of that room or virtual room you're having. And to go on to that, you tell your mediator, the person facilitating the agreement, the independent party facilitating the agreement, to keep certain things confidential even to the other side. But that effectively means you can say things you would not necessarily want to say in court, and maybe give stuff up and try and settle it with the confidence that there's never going to be any repercussions going forward. Someone's not going to be able to quote you in a courtroom or in a witness statement saying you said that, or you agreed to pay me X, when actually in your open position, you've said you're not going to pay me anything. So obviously the purpose of that is to try and facilitate the agreement between the parties openly and with respect of the confidentiality. And lastly, it's non-binding. And what I mean by that is that often you can have a full-day mediation, and offers can be made by you or the other party, but there's no reason why you need to accept that offer there and then on the day. So you can go in relatively relaxed. You can go in knowing there's not going to be a final determination at the end of it. Obviously, the hope between everyone is that it will provide a settlement for everyone. And the last one, I should say, at least in the UK and England and Wales, there are potentially cost consequences, adverse cost consequences, if a party refuses to either mediate or enter into any sort of ADR without good reason. And those cost consequences can be, you'll be penalised on your costs. You might get less costs if you don't mediate, or if you win, or if you lose, you may have to pay more costs to the other side. There are exceptions to that, but usually in England and Wales, you'd have to set out using the witness statement or to a judge the reasons why you may not want to enter into ADR. And those reasons could be because your positions are so different, you don't consider there's any point entering into any sort of ADR or mediation. But even so, I'd still advise you to advise your prospective clients in the future to at least consider an mediation or other forms of ADR, and hopefully your clients will agree to that. So as I say, what is the purpose of mediation? I say that it is trying to reach a settlement. That's not always going to reach the settlement on the day. There are statistics out there that say probably about 60 to 80% of mediations do reach a settlement, either on the day or, as I've often had the case, a few days later. It sets the parties' minds to actually what's the risks here? What's the risks and rewards ratio? They've made a good offer. I'm not prepared to accept it now, but sometimes parties want to sleep on it. And I've often left a mediation with an offer on the table, and either my client or the other opponent's client said, listen, we want to sleep on it overnight, have a think about it, have a couple of days to think about it. And then sometimes that leads on to an offer being accepted or some other form of negotiation between the lawyers or the parties directly. So it does facilitate and sets everyone's minds with the purpose of there is the potential settlements to go forward. And as I said, it is cheaper than litigation or arbitration. And as I said, it will hopefully protect you on costs. So what should you do when you have an agreement with the other party to have a mediation? You've selected your mediator. You've agreed a venue. You've agreed a date. That's all set up. What should you do? How should you prepare for that mediation? As I say, to reach your final and ultimate goal of reaching a settlement. And the obvious answer is in the question. What you need to do is prepare. And when I say prepare, that's to know your case and your client's objectives. And when I say to know your case, the purpose of mediation is not advocacy. It's not to persuade the mediator why you're right or why you're wrong, with exceptions, and I'll come on to those in a moment. But you should know what your case is about. You should know what your client's objective is, their open objective. What are they trying to achieve? Are they trying to obtain damages? Are they trying to obtain money? Are they trying to obtain a relationship with the other party? And obviously this all depends on what sort of mediation it is. If it's a family court mediation or commercial court mediation, what is the purpose? What's the objective? So prepare and discuss, not only with your client, but also nowadays, a lot of time the mediators, so there's independent party, will call the individual representatives up privately without the other parties being there and discuss the case with them, discuss their objectives. What's their client looking for? What's potentially what can their clients live with? What's essential for their clients? What won't they give up? And that's always useful to discuss that with the mediator, but prior to the mediation, because therefore the mediator can know when he or she is facilitating between the different parties what you and your client are looking for, how he or she can go to the other side and say, well, this is what they're looking for, this is what they're not going to give up, this is what they are, this is what's essential to them, but this is what they may be prepared to give up. And that does save a lot of time. And the trick is to try and get as much engagement with the mediator prior to the mediation itself, because that not only will save time in the long run, but it also means the mediator can focus on your client's own objective. You should also prepare a bundle of the essential documents. I have to be careful on this. I've been in mediations with 5, 6, 7 lever arch files of documents, and we haven't even opened one single document once, or we've gone to 1 or 2 documents. When I say prepare a bundle of documents, this is not a court case. You're not going to be referring to X, Y, and Z paragraph of whichever statement or expert report. Or to have copies of at least the pleadings, so your claim, any defence or response, maybe some witness statements, expert reports, key documents such as a contract. Have those in a probably, let's say, 1 lever arch file, maybe 2 lever arch files, depending on the size and the number of documents in your case. But have those prepared. So if you need to, if you just want to refer back to a particular clause of a contract, you can easily go back and go, well, clause X says this. So that's very useful, and obviously will save time going forward. Usually it's a requirement. What I say a requirement, usually it is expected that the parties will file, which will go to not only the mediator, but also the other side prior to the mediation. And what a position statement is a statement briefly setting out your case, and obviously, again, concentrating on the strengths and weaknesses of your case, but also will set out a history of any settlement discussions or offers that have been made in the past. And look at that, not only to try to persuade the other side's legal representatives, but the other side's clients themselves, the actual party themselves, but also the mediator. So it should probably be about 1 to 2 pages long, but setting out your strengths and weaknesses in your case, what your client's were looking for, but also a brief background of any offers that have been made, because the mediator will see that, and he or she will know, what to concentrate on when he or she is going to the other side and trying to facilitate that settlement. And as you've probably been taught elsewhere, the mediator's job is to facilitate a settlement. And the next point is to discuss, and this is slightly overlapping with what I've said before, discuss the aims and objective of the mediation with your client prior to the mediation, if possible. So that is setting out, if you've got a claim for, let's say, for sake of argument, £100,000, what's the minimum? What's your bottom line? How much would you be prepared to walk out with today if an offer is to be made or accepted? What if it's a family dispute? What would you like to do? Would you like custody of the child? Or if it's a contractual dispute for some supply, do you still want a relationship with that contractor? Have those aims and objectives beforehand, because then you can know and point the mediator to those objectives, and you will more likely than not achieve a better result at the mediation if you prepare beforehand. And of course, give your client a risk-reward ratio. If you go to court, it's likely to cost you X amount of pounds or dollars or whatever the currency, cost you a lot of money. You may or may not have a good, strong case, but obviously we cannot guarantee in a court that the judge will find in your favour. So that's why it's always better, not always possible, but always better to try and have a mediation early as possible before the legal costs starts racking up. Often I've been in mediations where the costs have become a factor because the mediation has been left so late. The costs have become a factor of why a settlement hasn't been reached. Well, yes, we would be prepared to accept £70,000, but our costs are already £70,000. So in a month's time, we'd rather go to court. But have that conversation with your clients prior to the mediation and give them that advice. So moving on to the main thrust of the topic today is creating rapport with the opposing party and also the mediator. But I will concentrate more on the opposing party. And just a caveat to this: this is not always the case that you can do this. This I find it helpful. I've been in mediations. I'll come discuss some anecdotes later on, where the opposing party have just sat back, had no engagement whatsoever, and trying to create that rapport has been extremely difficult. And I'll come on with that going forward. But personally, I find mediations where you have created a rapport with your opposing party, the lawyers and even the party themselves, has created more of a spirit of cooperation. It's put everyone at ease, and your client at ease as well, because going through a court process is stressful for a client. It costs a lot of money. You're never guaranteed, even the strongest case, you're never guaranteed 100% to be successful. And at least in England, if you lose, you'll have to pay the other side's costs as well. So going in there with that spirit and open-mindedness to try and create a good rapport with the other party will more likely than not, in my experience, mean you've got to get a successful mediation. And also it will show that the mediator, that you and your client are entering into the mediation on a bona fide basis. Sometimes not everyone goes into a mediation on a bona fide basis. They go in because they have to. And that's going back to the English system, where you might be penalised if you don't engage in mediation, penalised on costs. So sometimes people go in just to tick a box. We've mediated. We can say to the judge, obviously you can't say what's actually happened in the mediation, what offers have been made, but you can tell the judge that you have mediated, you've entered into these settlement discussions. But it can be a tick the box exercise. Or sometimes people go in, and I have myself, you sometimes want to go in to try and engage what evidence, the strength of the other side's case, as a bit of a fact-finding exercise, with the caveat again that you can't use openly what's been said in the mediation in open court or correspondence with the other side, but there are ways and means you can try and openly obtain that information. But it's always good to see in a mediation what the other side thinks is the strongest part of their case. So that's another reason, and to go into that. But ultimately, that if you're going in with that mindset, you're not going to reach a settlement. And if the other side had gone into that mindset, you're not going to reach a settlement. And of course, you cannot control what the other side are going to do. But I consider it was always best to go into a mediation with an open mind, with a willingness to settle. And of course, settlements doesn't mean you're going to get everything you've asked for, your client's asked for, but it's walking away at the end of a mediation with what you think, well, your client thinks they can live with. They're not necessarily happy with it, but they can walk away with it, and it's all done and dusted. There's no more stress. There's no further legal costs. They've de-risked the case, and they've gone in. So to go in with that mindset of actually settlement and creating that rapport with the other side, albeit you cannot control how they're going to react to it, is, in my opinion, going to mean that the mediation is going to be much more successful. And that's going to, because as I say, create less stress for the client. And it also means the other side will become more cooperative. If you go in all aggressively, going, right, my client's going to win this, I want 95% of everything I ask for. I'm not going to listen to anything you say. You're not, in my opinion, going to create a successful mediation. The atmosphere will mean the other side will close up. They won't engage in the mediation. And that goes on to the next point. It minimize the hostile environment. Again, that is not the best mindset that's going to create the best atmosphere to create a successful mediation, and therefore hopefully a settlement at the end of it, or very shortly afterwards. So here are my top tips. And you might have, in your experience, other top tips. There might be other things that you think does create rapport. So this is this is from my own experience, will create that rapport with the other side. Again, to try and reach the atmosphere so parties can reach a settlement. So how do you start off going into mediation? You obviously go informally, you shake hands, a mediator will introduce the parties, but I think it's quite nice to go around, and often the mediator one, he or she will do this to create that atmosphere themselves, but it's often good to create an atmosphere where you introduce yourself, introduce your clients, say a bit about yourself, maybe speak about the football last night or something, or the weather or something, breaking the ice. So you're not going in aggressively, adversarially, you're going in, again, with that spirit of compromise, spirit of settlement. Put yourself in the other party's shoes. This is more thinking about when you're planning with your client, well, what does the other side think? How are they going to react when we make these offers? What's there? Almost playing devil's advocate. So putting the other side's shoes. Well, yes, I can see where they're coming from. I can see why they would say that. Why they'll say that. So is there anything we can do to alleviate that problem? What's the hurdle? What's stopping us getting over a settlement? What do you think they're looking for? How can we address that? What can we give up? Non-essential part can we give up to make them feel comfortable, make them willing to cooperate and make an offer or accept an offer? Body language and tone, I think, have to be the next one. As I've said from the start, a mediation is not a court process. You're not there to prove to anyone who's right and who's wrong. Obviously, concentrate, pick out some good parts of your case, strong parts of your case. Don't get me wrong. But you're not there. You're not going to get a binding decision. The mediator's job is not to say, well, yes, you're right. If this goes to court, you will win. That's not what the mediator's job is to do. It's so going in aggressively with a tone, aggressive tone, will mean the other side may just shut up shop. Maybe they'll close up. Maybe they even walk out the room. So going in that with a friendly, open tone and body language, and listening to what the other side say without interrupting them. Actually hear them out. Think about, as I say, put yourself in their shoes. So tone, body language, sit up straight, look at them. That doesn't mean, and a tip one of my professors said to me is you don't need to actually agree with everything they say. You don't need to say, yes, I can see that. Just or even nod your head, but still listen to them. Don't interrupt them. Don't argue with them. If they are wrong factually, point them out politely. Point them out. Or actually, you'll find in your witness statement or in your case that you said this. And here's where it says in the bundle. Just stop there. And that's going on. Be polite. Avoid any criticism, personal or with any of their case. Just understand where they're coming from and listen to what they say. And also summarize with them this is what you've said, isn't it? You've said this, and you've said this is the main point you're looking for. You've said you're willing to offer X, Y, Z. Am I correct in that? So make sure there's no misunderstandings with them. So just summarizing, just go in politely, firmly. You don't need to be too pally with them once you've broken the ice, but demonstrate that you are there with a willingness to try and settle the case if possible. That's not always going to be the case, but if possible, it does create that atmosphere where the other side's put at ease. They can understand what you're looking for. They can understand what they're looking for. And often I find it quite useful to have your clients give a speech at the start of the mediation, especially if there's, it's all on a case-by-case basis. But if your clients have been in a relationship, business or personal relationship with the other party, and they feel aggrieved, it's quite nice for them to sort of get that off that chest. I've worked with you for 30 years. We've always had a good relationship, but I feel that you have done something that's caused me to bring this claim, bring this action against you. I was upset about how you treated me, etc., etc. Obviously, it's again case specific. Not all clients want to do that, and obviously that's something you'd need to discuss with your client beforehand. But sometimes it's good for the parties to clear the air beforehand. Right, going on to some anecdotal stories. So I've got a couple, good and bad stories from my own experience. And to start off with, a good one to start with was where the parties we had a mediation. It lasted, I think it was probably pretty much all day or the best part of the day. And we didn't reach a settlement. There were some offers being made. We didn't reach a settlement. And usually, parties shake hands and say goodbye. Each party goes off, and their legal representatives will go and discuss with their clients on their own time, separately. But on this occasion, after having it was quite a stressful mediation, the mediator said, "Well, we've not reached a settlement. Let's shake hands." And the parties then decided to go off to the local pub all together, and just to say, because they've been working together for quite a number of years, and have a drink afterwards. And the parties got talking to each other, and probably outside of and I can understand it's a stressful situation, albeit it's not court. It can be stressful. The parties got talking to each other, and afterwards they said, "Well, actually, do you know what? We would like to, create the relationship. We would like to, come to some sort of compromise." And then we all went back to the mediation room and we bashed out a settlement. There was that rapport that outside the more formal structure of a mediation, where everyone was able to relax and actually say what they wanted to do. I can't say that's I would recommend doing that all the time, that you go to the pub afterwards and probably 99 times out of 100 that's not going to work. But on this occasion, it was a good way of those parties to actually reconcile with each other, and eventually that did reach a settlement. The other story is the reverse of that, when that happened actually quite recently, probably about 5 or 6 weeks ago. I was representing a claimant on a case. We had the mediator. We did all the repair work that I've gone through in this webinar. And the first thing, the mediator invited the defendant's party, representative of the defendant company, to say a few words. And he accused my client of fraud, of making documents up, of fraud, of something that's never been mentioned at all in any correspondence. It's never been mentioned at all in any of the court documents. He said, "We think your client has committed a fraud." Complete bang, complete out the blue. So I've just had to say to my client, to the mediator, to advise my client, if those have never been made before, that's not conducive of reaching a settlement today. If you're going to make those allegations with no evidence to back them up, that's not how we should be conducting this mediation. And if you continue making those allegations, I'm going to have to advise my client to walk out. And eventually the mediator then went to the other side, and it was informed they're not going to make those allegations. Unfortunately, we didn't settle at the end of the day, but it upset my clients. They said, "Well, what on earth are they doing here?" It wasn't conducive. It wasn't creating rapport. It was doing the opposites. Perhaps they did it because they thought they'd scare my client into making a settlement offer or accepting a settlement offer, but it had the reverse effect. It just made my client quite angry, to be honest. It did not create an atmosphere of cooperation, of compromise. It just created an atmosphere of closing up. Let's go through this. Let's get it over and done with. But if they're going to make those allegations, we're not going to reach a settlement today. So that's something how you shouldn't do it. So I'm not saying the first one is how you should do it, but there's somewhere in between. There's to be firm but polite. Don't make allegations that have never been raised before in the past. Obviously, if they have been raised before in the past, you potentially can bring them up. To persuade, why the other party should settle or accept an offer, but not for the first time to bring up serious allegations like that. Is not, in my opinion and experience, is not during a mediation. Right. So I mean, that brings the webinar to a close, or my part of the webinar to a close. I've got some questions here. I don't know if you've got any questions to start with. I can go through some questions here.
We have had a few good questions, actually, Edward. So would you like me to go through what I've had from the audience?
You go through them. I'll try and answer them.
Okay, thank you. It's been a lovely session, first of all.
Thank you.
Someone has asked, what can be a few ways to break the ice with the other party to start off the mediation process? Yeah,
well, that's a good question. I mean, it's all obviously case by case basis. I mean, I think it's good to, obviously there's three sets of people there. There's usually the claimant side. I mean, there might be more depending on if there's more parties. Let's say there's a two-party claim, claimant and defendant. So there's usually someone representing the claimant, and there's usually someone representing the defendant, and there's maybe one or two lawyers on each side and a mediator in the middle. So it's good to speak to your client beforehand, who usually knows the other party. You know, what sort of character, what sort of temperament they like, what do they like? Is there something, you know, are they into football? Are they into cricket? Or do they like, you know, whiskey, anything? So if your client knows that particular, and it may not, I mean, you know, it might be a representative of a bank or something like that, you know, but if your clients can give you some insights beforehand, what sort of person that is, that's always helpful. And then obviously if they do like cricket and or football, and there's a football match last night, maybe bring that up. If you don't, you know, I think it's just to be that polite, and maybe start talking about something nothing to do with the case. You know, talk about the weather. Hopefully, we're, you know, not talk about COVID too much because everyone's sick of it and restrictions. But there might be something, you know, to find just completely outside the actual case or the dispute that's happening. So it's really, as I say, it's a case by case basis. Either because you know that particular party, either that particular party knows, or they got an interest, and then there's the common interest. I think that's always good. Have 5 minutes talking about something completely outside the topic and disputes, because it puts not only your client but their clients and everyone, it relaxes them a bit more.
Okay, thank you. I suppose every situation is different, isn't it?
It is, yeah.
Someone else has asked, how can you show empathy to the different parties whilst remaining professional and not appearing biased towards either side?
Yeah, no, that's another good question. When I say empathy, I think that is putting yourself into their shoes. So obviously, most disputes, they may think that they may feel aggrieved. It depends. I mean, it all depends sometimes whether you're the claiming party or the defending party. You know, putting yourself and going, listen to them, think about how they may feel if you've said something. So not to try and upset them, not to be aggressive, but thinking, well, actually, I can see. You don't need to say this out loud, but you can maybe advise your clients. You can see why they may feel like that, and is there anything we can do to alleviate that? You know, partners who've been, or business partners have been in business for 20, 30 years, and then suddenly you're making a claim for them for $500,000 or whatever it is, or accusing them of X, Y, and Z. You know, you can understand that they might be upset. That doesn't mean you can't use that to advantage. You can push some buttons. You know, I don't want to contradict my whole webinar, but you can push some buttons because, well, actually, you know, what's the main thing that would mean that they will settle this? Is there anything we can utilize or hinge on? But just think about how they may feel for one moment, because, as I say, you're not going to walk out there with 100% of what you've asked for, or if you're defending, you're not going to walk out there with nothing. You know, paying nothing, for example. There's going to be, if you're going to reach a settlement, there's going to be somewhere in the middle, somewhere. You know, so just think about that. One thing is quite useful is there anything, you know, there might be several facets to your claim. Is there anything you could give up? Essential thing that you could give up? Could it be, let's carry on with a working relationship? You know, sometimes the trust is broken down, so that's not it's a non-starter. But could we still have a business and working relationship with them? Because that's important. But we still want some money because you caused us damage. So I think that's, again, it's sort of a case-by-case basis.
Okay,
and go on to that. Sometimes the battle is actually trying to persuade your own clients that we can understand that's how they may feel, whether you agree with that or not. But they feel aggrieved. They feel that you've done something wrong. You can understand, just putting that aside, whether you have or not. That's how they feel. So what can we do about that? How can we go beyond this?
Yeah, it sounds like it's a skill that you develop over time. Like, would you say it comes with practice?
Yeah, it does come with practice, like most things, and it also sort of comes with. It's not always easy. I mean, I say this again with the caveat. Sometimes it always depends on how the other side is going to react. Because if they come in all aggressively, like the story, the anecdote I mentioned, you can prepare to do this as much as possible, but they may do something that is not conducive of entering into a cooperation, a settlement, a proper settlement. It becomes more adversarial. Right, you're going to lose. You're going to lose. We've got an amazing claim because this case says that it's not. This is not the forum to do that.
Yeah.
But sometimes you can't control the other parties. You can advise your clients, and you can prepare. But you can create that atmosphere to put them at ease, the other side at ease as much as your clients.
You mentioned earlier in the presentation that sometimes, because of the penalties in English law, some parties will come to the mediation table just to tick a box, basically. Yeah. And we were wondering, is there any way that you can persuade those kind of clients to view mediation as a viable solution?
Well, I think you can if it's your own clients. If your own clients, obviously you as solicitor, you would need to advise and tick a box for the court that you've advised your client the benefits and I mean, it doesn't have to be mediation. It could be ADR. It could be anything. So you advise your client. That well, actually, if you've got a really strong case and this, that, and the other, I think you should still enter into mediation. But because it's going to save costs in the long run. But you can persuade your client. They will actually, the other sides, if we go to that, they're not going to be able to pay. We might get this amazing awards judgment and costs in our favour, but how are they going to pay it? So it might be a commercial settlement, so that's going to be in your favour. I think you can point out the pros to your client. If your client says, well, the other side, they're just going to tick a box, they're just going through this, well, perhaps then mediation is not the right process. Maybe you could just have a round table discussion, which is effectively, it's more than one way of doing it, but it's sitting around a table on a conference call, lawyers to lawyers, party to party, or both, all on a without prejudice confidential basis. That would still be ADR and tick the box, and it's going to be less money. You might do that for a couple of hours without incurring the cost of a mediator and hiring a room or facilitating online. But I think you would have a duty to point out the pros and cons to your clients. But again, you can't force the other party to mediate. If they say no, or to enter into ADR, if they say no, there's not a huge amount. Having said that, there are talks about having compulsory mediations or compulsory ADR, and they are, in England anyway. So that might be something that will happen. Again, you can't stop someone ticking the box. That might mean more people try to tick the box because they have to. The court has ordered them to, and sometimes it does happen in court. The court judge can order parties to mediate. But yes, you can't. Obviously, you can set out in writing to the other party why we consider mediation is going to be beneficial, not only to our client, but to your client as well.
Yeah, of course. And are you able to tell us a little bit more about the penalties in English law where parties might be scrutinized by the court because they haven't?
Yeah, well, in general, it's cost penalties generally. So if a party refuses to enter into ADR, it doesn't, as I say, it doesn't have to be mediation, then they need to explain to the court a good reason. I think they might even have to put a witness statement in from either the lawyer or the client saying why. And there might be a hearing on it when it comes to the end of the case, when the case has been decided. Why was that a good enough reason not to engage in ADR? But if they haven't done that, or the court says that's not a good reason, then if they're the winning party, the court can reduce the amount of costs recoverable from your client. They'll get less costs effectively, or interest. There'll be some pecuniary adverse consequence, or likewise, if you're the winning party, you might be penalised. Your client will get less costs. They won't, the court can go, actually, we'll reduce your costs or an interest on your claim. So there are financial incentives over and above the pros and cons of mediation, and not incurring reaching a settlement early on and not incurring your own costs. There might be financial incentives later on from the court imposed pecuniary or adverse cost consequences.
One of our participants has asked about how you deal with mediating where the other party is representing themselves. Is there anything that you change about the way you conduct the mediation?
Yeah, I mean, I think well, it's yes and no. I mean, obviously, as I said before, it's not a court case, so you're not trying to persuade, referring to lots of case law anyway, even if they are represented, unless there's an absolute case on point that means something. Obviously you can. I'm sure that would have been raised anyway in correspondence or your pleadings, but I think you're not using too much legal jargon, and there's no point confusing them because they're not going to make an offer. But I think this is where a good mediator will come in. The mediator will usually try to explain it. Maybe you're not even in the room with the mediator, will be alone with that party, and he or she will go through it with them. So you probably would use less legal jargon, but that doesn't mean, obviously you've got a duty as a lawyer not to mislead anyone, the court or any other party, but that doesn't mean you can't, dare I say it, take advantage of it. So it's that doesn't mean you can't, as long as there's a legitimate point, you can take advantage of it. But if you're quoting a case, even albeit it's a case that whereas just think the other party, if they're not represented, might not understand that, so it might go over their head. So is there any point? It maybe try to explain it in a bit more detail to them. Well, this case means that, and that means that. Do you want to go away and think about that? Or do you have a lawyer you could call, on standby or anything like that? Or we'll come back on that point afterwards.
Okay, thank you, Edward. I think we do have one more question. A lot of our participants have asked about the difference between mediation and arbitration, and when it would be more suitable to use mediation.
Yeah, well, again, a good question. I mean, the answer can be answered for you in that starting point of looking to, if you're going through the courts or arbitration, starting point is to look at if there's a contract in place. So on the contract, it may say any disputes have to be resolved going through arbitration. So you go through the arbitration process, and it may say the number of arbitrators, it may say the seat, the language, etc., etc. So if you do that, there is a mandated arbitration process. There might be a mandated mediation process as well in the contract. You know, I've had it. There's a dispute resolution process where parties actually are mandated in the contract to go for a mediation. But if it is arbitration, that means you can't issue it in the courts. And if you do, then there might be applications to stay the claim to go for arbitration. But the answer to that is that even if you have an arbitration, that doesn't mean you don't. It's still a process where effectively you're persuading someone. In this case, either a single arbitrator or a panel of arbitrators, why you're right legally and factually, and they'll make a decision on it. So albeit it is ADR, it's not the same as trying to settle the matter out of a institutional process such as the court or an arbitration. So you can still have a mediation in an arbitration. So you can you'll start your arbitration. You'll just that at some point you go, let's stop this for a while and have a mediation. Conversely, if you're in the court process and you can go, well, actually, we'll stay the claim, but even though there's nothing in prior in the contract that forced us to go for arbitration, we can effectively, and so there's nothing stopping us issuing the claim against you. We can agree either post-issue or pre-issue. We can agree to go through the arbitration process rather than through the court process. But really, to answer the question, I think even if you have an arbitration, you probably should still do a mediation, if possible, or some sort of other form outside someone determining your case for you. I mean, what's another process for ADR now is something called expert determination, which is effectively, again, it's all without prejudice, and again, it's non-binding, but it's a process where maybe a judge or a retired judge or a barrister or someone will have almost, it will go through either on the papers or there might be some representations, go through each party's case. There might be submissions, written or oral submissions by counsel on either side. There may even be some witness evidence, probably written rather than cross-examination. And that expert, and it could be a construction case or it could be a quantity surveyor, again, depends on the case, will say, well, if this goes to court, I would find in your favour. I've looked at all the papers, I've looked at all the submissions. If this goes to court or an arbitration, if I was the judge sitting on that case, I would find in X party's favour. The difference between that is it's non-binding. So you could go in, wow, yeah, that's fine. They haven't got an power to, and it's also confidential, so you can't refer to it in court. You can't say, well, actually, we had an expert determination and they found in our favour, therefore, as some evidence. You can't do that. But what it does do is that it focuses parties' minds. They go, well, hang on a second. Well, our case is stronger or it's weaker, than it was, and you might lose this. And there might be some offers made at the end of it on the same day or afterwards. So that's something else that's starting to happen more and more in the UK or in England. Again, that is a form of ADR, a form of alternative dispute resolution, albeit you can be in a court, you can be in a private session. But I know there are caveats there that you may say, or your client may say, well, actually, no, they haven't got all the evidence. We haven't had full disclosure of all the documents. There might, but it's a good steer that if this goes to court, well, you may lose. The expert said you may lose. I'd find in the other party's favour. Or let's think about what we're going to do on this.
Thank you, Edward. We have about 5 minutes left. I don't know, I'm conscious that we've had a lot of questions. Was there anything that you would like to talk about before we wrap things up? Or?
I mean, yeah, I think a lot of the questions are the ones I had here already. One question I did have or wanted to speak on is, does the quality of a mediator make a difference? And usually the process in England anyway is usually one party will suggest the names of pre-mediators, and the other party usually picks one of those mediators. Usually it's someone with experience of the case, if it's a contractual or construction or family or what have you. But they'll look at it and hopefully you've used that mediator, those three before, and you found them to be a good mediator. And so you've agreed a mediator, both parties, because you can't be forced to into it unless there's something in the contract already. But yeah, the answer is it does help, because the mediator's role is to facilitate that. And I've had good mediators and I've had bad mediators. So to answer that question, it's if you're the party, and you can't, obviously you don't have to choose any of their three mediators, you can come up with your own. But once you have that, I think it's important to try and propose three good mediators, from experience, from anecdotal experience or your own experience, and look at their CVs, look at some of their feedback, look at how good they are, because I think that the quality of a mediator. So when you are going through that agreeing the mediator's process with the other party, trying to pick someone who will facilitate or is good quality, because that can be the difference between settling or not, is the quality of a mediator.
That's very helpful advice. I'm sure that you've given a lot of advice today that will help our students and our recent graduates who are just beginning their careers in law. So I think we're about to wrap things up now,
Yeah.
But I'd like to say thank you, Edward, for taking your time today to come and deliver such an informative session. Is it okay if we share your presentation with the participants?
Yeah, and if you send it around, and there's my contact details if anyone's got any queries.
Okay, wonderful, thank you. So if any of you have questions that we haven't managed to get to, then you can forward them to Edward's email address there, and Edward is happy to answer those. Before we leave, I'd like to take the opportunity to just introduce Mediate Guru's International Arbitration Moot competition that will be hosted this upcoming September. If any of you are interested in learning more about arbitration in the practical process, then this would be a fantastic opportunity to get involved with. For more information, you can go to our website, www.mediateguru.com. I'd also like to request that everyone please fills up the feedback form before you leave in order to receive your e-certificates. And if you don't want to miss any updates from Mediate Guru, please follow us on our social media handles, which we've posted in the chat. And you can also join our WhatsApp groups, which are linked there too. So once again, thank you everyone for joining us, and I hope that you have a wonderful rest of your day wherever you are. I know it's evening for some of you, and hopefully we'll see you all again soon. Big thank you to Edward again.
Thanks everyone, thank you. Take care, have a good evening or afternoon.
Thank you.
Take care, bye then, bye.